And here's what I love about family law is it affects the most important things in our lives. It involves our children, our finances, and our dignity. Those are the things that you stand up for, you get up for every day. So come to court and treat it like it matters. Because if it doesn't matter to you, guess what? It doesn't matter to the court. If you don't believe that it matters, the court doesn't believe that it matters. So when you show up, be serious about it, do it with conviction. Hey everyone, I have 10 courtroom mistakes that will destroy your case that you need to know about and how you can avoid them. Family court isn't just about knowing the law. Most people lose their case because of the mistakes that they make in the courtroom. And here are the 10 biggest mistakes that I've seen over and over and how you can avoid them. Mistake number 1, being unprepared. Judges can spot it instantly. No organized notes, missing evidence, showing up with excuses instead of documents. Preparation is respect for the court. Lack of it tells the judge you're not serious. Always bring every paper organized, even if you don't think you'll need it. The person that comes to court and has unorganized thoughts and tells stories and just keeps going from one event to the next with no real structure or agenda to it is easily spotted as someone who is not prepared. You need to spend more time thinking about what you're going to say and do in court than what you actually do in a courtroom. That's where the important time should be spent, is in the preparation, so that when you come to court and you say things or give things to the court, it has value and it matters. That's the most important thing. Here's mistake number 2. It's interrupting the judge or opposing counsel. Cutting people off, it might feel good in the moment or maybe even natural for you, but in court it's just poison. It shows disrespect, and judges do not forget that. And they'll cut you off and they'll tell you, ma'am, sir, you cannot talk over me. So you need to take a breath, wait your turn, and when you respond, be direct and not defensive. You want to come across as a person of authority, someone who is respectful to the court and opposing counsel, and guess what? The court and opposing counsel has to be respectful back to you because you're demonstrating that to them. It's simply the golden rule. Here's mistake number 3, letting emotions take over. Family court, as you guys know, extremely emotional, but yelling and crying uncontrollably, rolling your eyes, or slamming your papers, it just weakens your case. Judges want stability, and the person who stays calm under pressure always looks more credible. There are some exceptions to this. There are times in a courtroom where you have a very human moment, and there is a reaction. So you might need to have some tears or cry because you're simply taken over by the moment. The point is, it's genuine and it's authentic. But what you want to avoid is if you hear things that you don't like, whether it's from the court or opposing counsel or someone else in the courtroom, that is not the time to be demonstrating that, showing poor body language or using words or gasps. And here's a side tip for this. If you're bringing family, friends, or other people into the courtroom to observe, make sure that you and your attorney are telling those people, hey, you're here to watch. This is a courtroom, not a living room, not a bar, and you need to act with respect, because sometimes those people that you bring can do these things, and that affects the court, and the court sees you associating with folks who are disrespectful, and that can hurt your case. You just simply don't want it. So make sure to give that warning to the people that come to court with you as well. Here's mistake number 4. It's talking too much. This is huge. Rambling, oversharing, going on long tangents makes a judge tune out. Less is more. Answer the exact question asked, keep it short, keep it clear, and then stop talking. I see this often, and it comes across a lot of times to the court that the person being asked the questions, if you're a witness in your case, and you're being asked questions by either your attorney or the other attorney, or sometimes the judge, if you don't answer the question directly, it comes across as if you're being evasive. And judges are smart. They sit in the courtroom all the time. And I've heard judges say, you're not fooling me, you're not tricking me, answer the question. So what's the message here? Is answer the question. Here's mistake number 5. It's badmouthing the other parent. There's a difference between facts and badmouthing. I'll get to that. So if it's true, constant attacks on the other parent can backfire, and judges see it as immaturity or even parental alienation. Now, you want to focus, as I said, on the facts, what's best for the child, and not character assassination. So if we break that down, remember, courts are fact finders, and courts are required to follow, in Wisconsin, certain factors to determine what's best for the child for custody and physical placement. So you want your facts to be aligned to the factors that are in the statutes. If you don't know what those are, you need to read those factors in the Wisconsin statutes or make sure that you hire an attorney who understands them. So when you go to court, and if there's an objection that it sounds like you're either badgering the other side or bringing up facts that are not relevant, if somebody says that, you or your attorney needs to say, well, no, this is a factor, judge, that you need to consider in your case. You want to stick to the facts. And what I'm talking about is the things that the person said or did, not your interpretation of whether or not that means they're a mean person or a nasty person. You just want to talk about the observations, things you saw or heard or read, or bring in witnesses that say those things. So stick to the facts, not your feelings about the events. Here's mistake number 6. It's ignoring courtroom etiquette. First impressions matter. Showing up late, dressed inappropriately, chewing gum, or checking your phone. Judges notice. Treat the courtroom like a job interview where the stakes are your family and your future. And don't forget, actually come to court, right? That's the number one thing. Courts are going to have a very hard time awarding you what you want in your divorce or custody case if you don't even show up. This should be the most important thing going on in your life. And here's what I love about family law is it affects the most important things in our lives. It involves our children, our finances, and our dignity. Those are the things that you stand up for, you get up for every day. So come to court and treat it like it matters. Because if it doesn't matter to you, guess what? It doesn't matter to the court. If you don't believe that it matters, the court doesn't believe that it matters. So when you show up, be serious about it, do it with conviction. Mistake number 7, guys, missing deadlines and procedures. That will be very difficult for you to overcome in your case. So filing late, not following rules, or failing to submit the right paperwork is one of the fastest ways that you're going to sink your case. Family court runs on deadlines, and if you don't respect the process, you risk losing before you even step in front of the judge. Here's mistake number 8, dragging your children into the drama. You do not want to do this. Nothing irritates a judge more than putting kids in the middle. Do not bring them into your arguments. Don't coach them on what to say. Do not use them as leverage. Judges will see it as harmful to the child, and it will destroy your credibility. This is a difficult thing for people because children, technically by the law, can be witnesses. In my experience, 20 plus years now, is that judges do not want a child of the parents coming into the courtroom, sitting there in front of their parents testifying about things. Can you imagine that? And you have to find a way to navigate through it. Sometimes people say, well, how do I do this? How do I talk to my children about this? You have to remember, I'm a lawyer. I put my lawyer hat on, and I tell people, I just know from the legal lens this doesn't work well. And I challenge my clients to think a little bit more thoroughly about how they can communicate to their children about hard things. And sometimes that involves bringing in counselors or talking to other people that they respect until they come up with a message that makes sense for their children, that's respectful of their best interests, and also has to be respectful of the other parent involved. It's just a fact. Here's mistake number 9. Is failing to listen. It sounds very simple, but it's overlooked. Many people are so busy thinking of what to say next or defending on what they just heard that they don't hear the actual question. They don't see how it hits the judge, how it hits the courtroom. And judges, they want clear, responsive answers. So listen fully, pause, and then answer directly. Here's what I tell my clients, and I know it works because I just got direct feedback on this. I tell my clients, when you ask this question in the courtroom, whether it comes from me, whether it comes from a judge or opposing counsel, tap your foot, okay? So the question comes in, tap, it causes you to pause and think about the question. You're not being rewarded in a courtroom for talking as quickly as possible. And in fact, when you quickly answer, I've seen courts slow people down and they say, sir, you need to take a break, you need to allow the question to come in, and then you need to respond. And so, number 1, I know the court needs to process the question, and the court needs to process the answer. And you should be doing the same. Now, at the same time, don't tap that foot so long that it comes across as if you're dragging your feet, literally here, and you're not answering the questions. But you want to do it in a way that allows you to process the question and then give an appropriate answer. Here's mistake number 10. believing that passion beats preparation. This is a silent destroyer of the case. People believe that the truth will come out if they just tell their story with enough passion. They come in and just tell the judge, I'm going to tell the judge everything I'm going to say. I've got all this on my mind. That's wrong. It's just as wrong. Courts run on evidence, documents, and preparation. And if you come in with all that emotion and you just want to lay it all out, it's not going to go well for you. Been doing this for a long time. That's not a strategy. Preparation is. You need to communicate this ahead of time. You need to get your thoughts down to paper. So you're going to think it, you're going to write it, and then you're going to practice saying it. All right? You're going to share it then in the courtroom. So when you have all those things and you tell your attorney or you tell your friends, oh, I can't wait for court. I'm going to say this and I'm going to say this and then say this and say that. Those thoughts that are floating around in your head, get them down to paper and have a strategy for when you come in and how you're going to say that in a proactive way that also shows you are under emotional control, right? You're under emotional control. It's very important when you're dealing with children, especially in family law cases. If you're representing yourself in a family court, avoiding these 10 mistakes, these 10 that we just talked about, is going to be very beneficial for you. Judges respect preparation and composure and clarity. If you're interested in more strategies to give yourself the best chance in court, check out my other videos on how to represent yourself. And don't forget to subscribe, because one mistake in court can change everything, and we don't want that to happen to you.